Today we're going to look at the variety of motions that you file in civil and criminal cases. We'll start off first with the civil matters and civil pleadings. Obviously, you want to make sure you're in the right jurisdiction and make sure you're looking at the right rules. Make sure if you're in civil law, you're looking at the rules of civil procedure. In this case, we'll be talking about federal. It just makes it easier. We'll talk about federal today, federal criminal and federal civil. We'll start off with federal civil procedure and motions. So Rule 12 is a motion for judgment on the pleadings. Essentially, if someone files a lawsuit against you and you look at it and you believe that there is no jurisdiction, there's no venue, improper service, etc., then you would file a motion for judgment on the pleadings. Pretty self-explanatory list. Rule 12 lists a good bit of incidences that pretty much speaks for themselves on exactly what you would, the basis on which you would file a motion for judgment on the pleadings. Discovery is a big deal in civil law. We know we've talked a lot about that here, but essentially in discovery disputes, you would file a motion to compel. In other words, you're trying to compel the other party, compelling them to provide you something or produce something or answer an interrogatory or produce you some kind of document that they're withholding. So essentially, you're involving the court there. You're filing a motion to compel, trying to get them to comply with the discovery rules. You may want to file a protective order too if there's some kind of trade secrets involved. That's a good example of a protective order. You would file a motion for a protective order and ask the court to actually intervene and say, no, that does not have to be produced because of the protective order. Summary judgment, pretty self-explanatory, but essentially it's that if you're filing a summary judgment motion, you're saying, Judge, there are no material disputes to issues of fact. In other words, this is strictly a court legal question. This is based on the law. This is based on, case law or rules, essentially. And so you're saying, court, I want you to rule on this summary judgment motion because there is not a jury question. A jury, obviously, as you know, a jury essentially rules on or decides on the facts. A court decides on the legal issues or the law. And so what you're saying is, Judge, this is basically a law issue. This has nothing. There's no dispute of material facts. There may be some disputes, but it's not material. So you're going to use affidavits or declarations, etc., to support that theory either way. And you're going to file that, trying to get the case, trying to get a summary judgment motion granted. So you also have a motion for judgment as a matter of law, and you're essentially there saying, Judge, this is usually in the middle of trial. You're saying no reasonable jury could believe that there's legally sufficient evidence to support this decision. So essentially, the judge is taking it out of the jury's hands at that point and saying that no, there's no way a reasonable juror could come to a conclusion here. And so that's what you would file there. Obviously, if there's any kind of legal error or jury misconduct or things of that nature, it's pretty rare, but you would file a motion for a new trial, essentially trying to get a new trial in front of the court. Motion to set aside a default judgment. If a default judgment was fraudulently or erroneously or by mistake received against you, then you would be able to file a motion to set aside that judgment or that order. And essentially there you got mistake. I mentioned this, but mistake, inadvertence, excusable neglect, and there's also fraud or misrepresentation. The book gives an example of fraud or misrepresentation, where for example, a complaint was filed against a defendant, and he told him, "Don't worry about the lawsuit. I'm not going to worry about it," and so he doesn't file an answer, and so the plaintiff got a judgment against him, and the defendant then filed a motion to set aside that judgment. So moving right into criminal law, one of the biggest motions in criminal law is a motion to suppress. Essentially there, if you believe that the defendant's constitutional rights were violated, usually it's Fourth Amendment, sometimes Fifth Amendment, but essentially let's use the quintessential example is a traffic stop. If the officer just pulled over the individual because they didn't like just how they looked, pull them over, walk up to the car, search the car, they find drugs and a gun, Then the defendant confesses, and you would file a motion to suppress, stating that officer violated constitutional rights because he seized the car essentially when he pulled it over on the traffic stop with no basis whatsoever. You have to have a basis, either reasonable suspicion or probable cause, to pull that car over based on the Fourth Amendment. So what you would say there is, Judge, we want you to suppress all this evidence and anything that flowed from that traffic stop, the confession also. And so sometimes a suppression motion, if granted, will completely gut the case. Sometimes there are parts of it that would still be valid. Like, for example, if you had a drug deal and you used an informant and you bought drugs from an individual and everything was fine, and then you ended up doing a search warrant on the individual's house, and let's say that the search warrant was just bare bones and did not have much probable cause in there, and it was essentially, the basics, and it didn't have anything specific in there. You could file a motion to suppress what was found from the search warrant. So if the judge granted the suppression motion on the search warrant evidence, you would still have the drug deal evidence alive, but you would not be able to present this search warrant evidence. So that's just an example of where a suppression motion may be granted, but it does not completely gut the case. Discovery is a big deal in federal criminal law. Not a lot of motions are filed, but sometimes they are. If the defense thinks that the prosecution has more information, they may file a motion essentially to compel. There are a lot of discovery obligations of prosecutors. They are required to turn over any exculpatory information that favors the defense, or the defendant, excuse me. And so essentially the prosecutor would have to turn over any information that's called Brady material. And I'll give you an example of that. Let's say that you had great evidence on the defendant that he let's say participated in the murder, but then you interview a guy who says, actually, I did it, and he confesses to the murder. Even if the prosecutor and the agent don't believe that guy, let's say we don't know why, maybe he was paid to confess, whatever, and they don't believe him, well, it doesn't even matter if the person's crazy and confesses to it. You would have to turn something like that over to the defendant because it favors him, right? And it's exculpatory. It could lead to his innocence. So that's an example of somewhere where the prosecution would have to turn over Brady material, and there may be motions to that effect where the defendant is saying the prosecution has violated Brady by not turning over certain things. So that would be another example of a motion. You got motions to dismiss for lack of jurisdiction. Maybe the venue's improper. Maybe the crime was not committed where it was filed. Maybe there's insufficient evidence in the indictment. Maybe the elements are left out of the indictment. As we talk about all this, elements are so important. Speaking of judgment of acquittal, Rule 29, that usually happens when you're in the middle of trial and the prosecution puts on their evidence. And then the defense, after the prosecution rests, the defense will file a Rule 29 motion for judgment of acquittal, and you essentially say, court, the elements have not been met, or they didn't prove that the defendant, that my client did it. So that's where you would file a Rule 29, and a judge would essentially take the case away from the jury at that point and just boot it out, and the indictment's gone, and that's it. Game over. That is an example of a Rule 29 judgment of acquittal, where you're essentially saying the jury, this doesn't need to go to the jury because there's not even enough evidence for it to go to the jury. So that would be a Rule 29 judgment of acquittal. Then you got new trial. That's usually like newly discovered evidence. Pretty rare. Granted, it's pretty rare. You may have a new witness that came forward or a new piece of evidence that was discovered. Motions to continue are obviously moving a date to the future, or just moving the date. It could be even before, but the catchword is motion to continue. Then you got standards of review. You talked a little bit about that. A court, and this is not necessarily a motion, but a court is going to follow the standards of review. In other words, they're going to look at precedent and the rules to see how they're going to rule on that motion, right? And so they're going to use those cases to decide how they're going to rule. And we'll talk about that later on. We've got a whole chapter devoted to that, I believe, later on in a different book. But Make sure you keep up with time limits. Local rules often govern time limits, and essentially, I mean, you may have just a response maybe doing 11 calendar days, but the only way you know that is through a local rule. It may not be in the criminal rules of federal rules of criminal procedure or the federal rules of civil procedure. You may have to look in the local rules. So make sure you're always checking local rules. We talked a little bit about that earlier in the year, but make sure you're looking at that. Everything's essentially electronic now, and not everything, but I'd say mostly. And we're talking about federal here, but you got to, what I created a verb, but it's called PDFing, right? You turn your Word document into a PDF and you're filing it as a PDF. But just pay attention to the service rules because they're very important. Obviously, as we talked about it with the local rules, but when filing electronic document, again, just make sure it's PDF. Make sure when you PDF it, it doesn't look crazy, because sometimes we've had incidences where a Word document, you may not look at it after you PDF it, and it's all wonky. So if anybody has any questions, let me know. But essentially, that is the chapter dealing with motions. Thanks.